At the end of your medical malpractice trial, the defense attorney turns to the jury and says, ladies and gentlemen, he's not entitled to any money whatsoever. But if you find that he is entitled to receive something, you should only give him this much. Can the defense attorney suggest a number to the jury about how much compensation you ought to receive? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. The answer is yes, he can. At the very end of your trial, the defense attorney will have an opportunity to talk to the jury about what he thinks the evidence has shown. And now he's going to make every argument possible to claim that, hey, you're not entitled to a dime. He's going to say that his client, the doctor, is not responsible, legally responsible for causing your injuries. Now, here's a different strategy that not many defense attorneys are going to use. They're going to turn to the jury and say, listen, it is our position that he's not entitled to anything, that our client did nothing wrong. However, if by some chance you do find that my client, the doctor, is responsible for this patient's injuries and now make a decision to give him money to compensate him, well, I think that his injuries are only worth this amount, not this amount that he's asking for. Is that a smart strategy? The answer is maybe yes and maybe no. There are some instances where the defense attorney presents an alternative argument like that. And now it gives the jury the opportunity to think, hey, wait a second. If he's suggesting a number, maybe he realizes that yes, his client is responsible. But the bottom line is, his client may really be responsible. And in an effort to buffer any type of amount of money the jury is going to give the injured patient in order to compensate him, he may turn to the jury and say, listen, this person might be entitled to some money, but his injuries really are not as bad as they claim it to be. And the value that they believe it to be worth? No. His injuries aren't worth that much. Instead, they're only worth this much. So that's an interesting strategy that some really smart defense lawyers will try and use when they recognize that it's almost inevitable that a jury is going to come back with a verdict against them. And now what he's trying to do is to minimize the amount of damages that his client is ultimately going to be responsible for. So why do I share this quick information with you? I share it with you just to give you an inside look at what goes on in these medical malpractice cases here in New York. You know, I realize you're watching this video because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.